a chance to set up and all of that good stuff?
I think so. And then if you could just put this one on you, that'd be perfect.
Okay. Let me see. Here's good?
Yes. And then you can just put that on your chair with you. I think that'd be fine.
Oh, okay. So how y'all been?
Good. How are you?
Cold.
Yes, definitely, right? Excited for Friday, though, I think everyone.
Yes, indeed. Yes, indeed. Okay. Maybe there's a way to click this. Will that work?
Yes.
That works.
We're good on the mic checks?
We're good on the mic checks.
Perfect.
All good on the mic?
All good on the mic.
Okay.
Perfect.
Great.
Okay, so just to get started, can we go ahead and get your first and last name and your title for the record?
Sure. My name is Gerald Byers, District Attorney,
Perfect.
3rd Judicial District of New Mexico.
Can you talk to us a little bit about IPRA requests and how they work, so we can set up a background for that?
Sure. So, the state legislature created a law. It is in Section 14 of the New Mexico statutes, and I'm not exactly sure how familiar you are with that since y'all are a Texas station, but essentially, there was a determination that said that it is a policy of the state of New Mexico for open government, that type of thing, and so that statute in Section 14, and it has many subsections, governs access to public records. It discusses things like what time limits there are for responding to a public records request, the nature of public records requests, what agencies can do whenever they receive one, and what remedies are available to those who request them, and the request is denied. It also provides options for costs and fees associated with agencies having to generate responses to those requests, and it also provides guidance on what would be described as burdensome requests, and also provides a description of circumstances where I believe the legislature, in its wisdom, saw that there might be a situation where requests would be frivolous, not just burdensome, but consistent, constant, and asking questions which an agency would not be able to respond to, specifically in the way in which the question is asked. And so it provided, I believe it's section 14-2-8, and it says that section provides that a government agency is not required to create an additional report in response to an inspection of public records act request.
Okay, so then moving on, can we go ahead and talk about your case management system? Are you able to submit queries? How does it work?
Sure. You have a list of questions there? Or?
Yes.
Oh, interesting. So the case management system is not governed by the DA's office. It is governed by the Administrative Office of the District Attorneys. It is managed by the Administrative Office of the District Attorneys. We merely access it, use it. We use that as a means of providing discovery to members of the defense bar. It is a means whereby we receive evidence from, the law enforcement agencies. We use it to maintain work product information. It has its limitations, but essentially that's the system that we've been using statewide ever since I've been a prosecutor, since 1997.
And are you able to submit queries on it? Like, would you be able to submit a query regarding dismissed cases?
That can be done, but here's the thing about that. Let me go back and modify that answer, because your question was, are you able to create a query associated with identifying dismissed cases? You have asked me that question before. Frankly, you've asked me that question a number of times. And I've answered that question before. I answered that question during the press conference that we provided in response to your initial piece that was broadcast and published. And that is, let me give you this answer. I'll say it again. The office has a responsibility to provide statistical information to the New Mexico State Legislature for budget-related purposes. That information is provided, and it's based on information that is stored and collected in the case management system. Now, that case management system is not capable of doing a snapshot in time in the past, but there are means whereby queries can be run. I'm not an IT expert, but what I can tell you is that we can have a query that will reflect the number of cases that had been dismissed. For example, last time you asked that question, the answer, I believe, was 1,782 cases were dismissed in fiscal year 2022, if my memory serves, and that was out of a total of, I believe, 5,680 cases. That's the information that is provided, and it came, I believe, in a time period that is associated with the fiscal year. If you are asking us for something that is January to December, and the way the system is set up is it will give you a response for a fiscal year, then because of the manner in which you ask the question, the answer is not going to be tailored to fit the question that you ask. You see what I mean?
Yes, but you are able to submit that query regarding the case dismissals.
I don't think you're following me.
Then can you explain? Because I guess I'm confused as to why your office isn't able to grant my IPRA request, but other offices are able to.
I see. Well, Ms. Parra, there's two things going on here. We are a profession of articulation and words. And I'm sorry if you can't form your question in such a way that it permits me to provide a product that meets your request. If you ask me a generic question or a question that is impossible to be answered, then I can't provide that answer. And let me ask this question of you. You ask us about case dismissals, right?
Yes.
Okay. And we gave you the answer that is found in New Mexico statutes 14-2-8. And it provides that nothing in the Inspection of Public Records Act shall be construed to require a public body to create a public record. We told you that. Yet you consistently keep asking us over and over and over again about dismissed cases whenever we have given you that answer. You asked the district court in Doña Ana County the same question. They gave you the exact same answer. The answer citing the exact same statute. But you're not consistently asking them over and over and over the same way that you are this office. So my question to you, ma'am, is why?
Well, I've asked the 2nd District Attorney's Office, the 10th District Attorney's Office, the 9th District Attorney's Office, and the 12th District Attorney's Office, and they've been able to provide me with every dismissed case throughout 2023. So I'm just curious as to why your office cannot provide that.
I'm not saying that we can't. What I'm saying is that the rule does not require that we do.
Okay, I understand.
Thank you.
I'm following.
I believe that we've answered that question, right?
But then I am curious, my next question is that why wouldn't you provide it for transparency reasons for your constituents?
Have you been paying attention to the news recently?
I work for the news.
Yeah, that's what I thought. We are a very busy place. We deal with a lot of serious issues. If you ask me a question and I give you an answer that is totally appropriate in accordance with the law, and I frankly could care less if all the rest of these agencies provide you their answers, because actually, so what are you going to do with the reports that you receive from the other districts? Are you going to analyze them? No, it's about the drama, isn't it?
No.
Yes, it is. So here's the thing. You ask me the question, I'm going to give you the answer. And the answer is that if you ask me a question and I provide you the answer, and the answer is in accordance with the legal statutes, I'm going to move on. I'm not going to get caught up in the drama. I'm going to move on because you mentioned constituents. Well, yeah, there are constituents, and they do care, and we care about them. I'm not looking in the rearview mirror about a question that you asked me. I held a press conference on, I gave you the answers, and even in your own report, you said yourself, let me see, last fiscal year, there were 5,682 cases that were filed in the 3rd Judicial District, Byers said. There were 1,782 cases that were dismissed. This is in your own report, ma'am. I've answered your question already, so why do you keep persisting on this?
I'm just wondering why you're not able to give it to me like they are.
Have you been listening?
Yes.
I've answered that question too. I said that I am deciding not to.
Okay.
What are you looking for? The angry black man interview?
No.
Then pay attention.
I am paying attention, and thank you for answering my question. I'll go ahead and move on.
Thank you.
So, the IPRA request that you are responding to with that statute, you've said that you're not required to create a new document like these people have.
Just like the district court told you.
Yes, I understand. I'm using that to start my question. I guess, why don't you keep a log of dismissed cases that would be readily available to share?
Because I don't cater to you, ma'am. You can come in and you can ask all of the why don't you this and why don't you that and why don't you the other questions. Let me ask you this. Why don't you ask your other competing stations how many interviews that they have done? Let me ask you, why don't you go and ask the Department of Transportation questions about roads and bridges and things of that nature? I could ask you all kinds of why don't you questions, but what's the point of that? What's the substance? I can tell you the difference between, I've been a prosecutor for over 26 years. I've been interviewed by people like you for over 20 years. The best interview I ever encountered was with Shelton Dodson. And you know how he did it? He called me up and said, hey, I've got a subject that's of public concern. I'd like to talk with you about it. Here it is. Okay? These are the questions I'm going to ask so that you can do your research and everybody can understand. And we sat down, and he asked me all kinds of questions, and I answered him fully. It was about Mr. Michael Toney, if I'm not mistaken. Okay, that should be in your archives. But instead, what you will do is you will call us at 10:45 or 10:35 in the morning, demand an appointment to speak with me, and then camp out starting at 1:30 in the afternoon. Ma'am, I don't live my life around your schedule.
I understand.
Thank you very much.
I guess then my next question is wording on the IPRA request. I know
Yes.
you talked about how everything's all in the wording. What would you say about, a former district attorney saying that that's playing word games?
I see. Well, I don't know what former district attorney it is that you're talking about. Who would that be?
Amy Orlando.
I see. And then are you in contact with her right now?
No.
Okay. So, just wondering, constant tapping on the phone. So here's the answer to the question. It's not word games. When an attorney opens their mouth, especially in court, it's not word games. This is exceptionally serious. This is a serious profession, just like yours should be. Okay? Now, the question is whether or not sufficient research has been done in order to properly frame the question. If I were going to go into a hospital and ask someone about an open heart procedure, I would be lost as to where to start. So I would do my research. I would ask people so that I would know the proper question to ask and how to phrase it so that I get the right and exact answer. The same thing is true in the law. You're asking about dismissed cases. Can you tell me how many different types of dismissals there are?
No.
You haven't found out, right? But you know what you could have done? You could have picked up the phone and said, hey, I've got a general question. Can you give me a little background information? Can you give me a little insight into what a dismissal is? Because there are dismissals of cases in magistrate court, in children's court, in felony court. There's also dismissals because of a procedural rule. There's a dismissal because of a trial. There's a dismissal because of any other procedural aspect. So when you ask the question about dismissals, you have to be specific. What are you talking about? And that's a fair question for me to ask back to you. So, I'm not here to try to be adversarial with you, but I will not be a doormat. And especially whenever I see things that are published in your broadcasts, which are not accurate, internally contradictory. You get Miss Orlando to get on there and call me a bald-faced liar with no basis. And if you haven't noticed, there's a lot of anger out in the public nowadays. That anger spills over into violent action. It puts public officials at risk. And Ms. Parra, I don't think that you have a vicious bone in your body. But if what you're doing puts me at risk, that's dangerous. And my life is not your toy.
I understand. I guess the reasoning behind these reports and everything, and I want to explain to you as well, is that these DA's offices, and I know you've already explained why that you can give this information, but you prefer not to. But these DA offices are being completely transparent by giving me these very detailed, showing me exactly how many cases have been dismissed, showing me exactly which cases have been dismissed, why they've been dismissed, and your office hasn't. What do you want to say to people who say maybe you're not being very transparent with your constituents by not sharing this information?
What you're presuming is that you are speaking for the constituents, right?
No, we've had calls.
Hold on. Let me answer the question. All right. You've had calls. Did you refer them to me? No. And you're going to sit here and tell me that you're not speaking for the constituents, but you're asking me to give an answer to the constituents, right? Look, I have been asked your questions many times, and all of the information that you're asking for is open record. The public can access it. You can access it. If you want to get all of the detailed information about the cases, you certainly may. Before you asked me about a case involving a guy named Nicholas Gorola, I gave the information about that because you had a family member that said, oh, the case was dismissed. I explained exactly why it was dismissed. It was not dismissed because the DA's office dropped it, as your reporting flatly said. No, it was dismissed because of a court order. And that case is pending trial right now because it's been re-indicted like I said it would, like it was in the letter that I sent to everyone. You're trying to make me out as being a disingenuous person. Ma'am, that is far from the truth, okay?
Okay. And then just going based off of, your website says that you'll be ensuring fair judicial process. Do you feel like you have been completing that goal while you've been in office?
The answer is of course. And here's why. We proceed as best we can with the evidence that we have to pursue justice in every case that is brought to us that is trial-worthy, that is worthy of prosecution. There are cases in which we deem that the case is not either prosecutable or, as a matter of law, it should not be prosecuted. I give you the case of King Munjin. It's a homicide case. And the question came down to whether or not we should continue to prosecute this death case. The man was sitting in jail. It was a dispute between two individuals on the street, and the victim was stabbed. The victim later on died. We looked at the quality of the evidence that we had, and we made the determination that the case should not continue. The defendant, hold on, I can't, it's closed, but I'm holding off on saying that because, let me put it this way. We dismissed the case, and the dismissal was not at the request of defense counsel. I made that decision. So, death cases are about as serious as they get. And for a prosecutor to decide to dismiss a death case is very, very serious. I did that because the state did not have sufficient evidence to proceed under the rules of evidence with what we had. We could have put on a sham and falsely convicted somebody probably, but that would be contrary to the interests of justice. So when you ask me about what's on our website about fair justice, yeah, I push as hard for fairness and justice in both directions. It's the obligation of the prosecutors to ensure the rights of the defendants are maintained. So yeah.
And then I want to go ahead and talk a little bit about the Supreme Court ruling, the case management rule that we've already previously talked about.
Yes.
I want to talk about how it's impacting your office. You talked about how you get at least 60 cases per week, but you're only allowed to arraign 40. How are you keeping track of those other 20? How do you prioritize them? Can you just talk to us a little bit about that?
Let me rephrase your question because the manner in which you phrased it is combining a number of different factors, okay? So
Okay.
If I rephrase it, then we're on the same wavelength. The case management rule adversely affects the ability of the state to bring cases forward and prosecute it. It shrinks the time frame in which we have to do it. It does not provide us additional resources, people, time, equipment, or anything else like that to do that. It provides avenues for sanctions up to and including dismissal of the case. And if you take a close look at the case management rule, the only entity that is going to be sanctioned is the state. However, the defense will claim otherwise, but just read the rule. So it does make it very difficult. With regard to arraignments, it's on page 3 of the case management order, if I'm not mistaken. Yes, it's in D, the number of arraignments per day. In this district, the number of arraignments the number of arraignments per day is capped at 40. This district has chosen to hold arraignments only one time per week. So, since you are obligated to have a person arraigned within a period of time after they've been indicted, if it is not held within that time, then the case gets dismissed. That creates a burden for us. A burden that I believe can be alleviated by having more days of the week available for arraignment. So in that scenario, it places an extreme hardship on the state, and it creates a situation where a case may be dismissed. And not only that, but the rule provides that if the case is dismissed twice, then the second time it is dismissed with prejudice. So what you could possibly have is a serious sex case or a serious homicide that is dismissed, and the victim gets absolutely no justice because of a procedural situation. And that is something that is exceptionally difficult to grapple with, and I believe that it is an artificial construct, because when you think about the amount of time that an arraignment takes, it's exceptionally minimal. And frankly, the courts have encouraged defense counsel to do what's called a waiver of arraignment. So then the court dockets are not clogged up with that. So that is the hardest part of it.
And then I just have a few follow-up questions regarding that. So dismissed with prejudice, can you just explain to our viewers what that means? Does that mean dismissed forever, can no longer be refiled?
That is absolutely correct.
And then, you talked about how in the third judicial court, you're only able to arraign once. You only have to take arraignments once a week.
The district court sets the cases for arraignment once per week, correct?
Why is that? I know that's not on you, but why is that, and how could that be changed? Is that something that's able to be changed?
We have asked the district court that many times. Our requests have been denied. I can't speak for the courts. I could only refer you to them for explanation that might meet your request. I can only tell you the historical, we asked, they said no. They gave an explanation as to why. Lack of manpower, lack of time to schedule it. And, I don't want to defend or attack, but what I can say is that it's my belief that the court system in the state of New Mexico is overburdened. Period. I'll just make that blanket statement. Focusing on the third judicial district, I believe that the public could be better served by having more judges, more staff, more equipment to manage the flow, and that might put the district court in a position to where the pressures would be alleviated such that they could honor our request. I don't know. That's the best, presumption that I can make. But what we are doing is we are doing the very best we can to work with what we have. And, I don't direct the court to do anything, don't have that authority. That's the way the system is structured, and I'm not in a position to challenge that in any way.
And then, I guess, how do you prioritize which cases get arraigned, knowing that you have more cases coming in than what you're able to arraign?
Thank you for that. There are a number of factors that go into it, but let me say this. Part of the reason I touched on earlier concerning the amount of time after the individual has been, the case has been indicted, that's one factor. If we look at a case and all of a sudden we realize that it is, well, let me back up. The sequencing of arraignment is based upon the indictment. What we can do to answer your question of how do we decide which ones to do or which not, we can affect that by the determination of when to take a case to grand jury. Because once the case goes to grand jury and a true bill is issued, then the case will be set for arraignment, and the court will docket that. Okay, but as far as every case that goes to grand jury gets immediately set to be arraigned. And if we have a case like, let's say, it's a property crime, and we only have the ability to bring 30 cases to the grand jury, and we have another case that's a child sex case, and we got to decide which one goes, and both defendants are out of custody, well, the child sex case is going to go. It's going to get the priority. If the defendant is in custody, then we are under obligation to take that and give that priority, because the state of New Mexico places a premium on an individual's liberty.
Okay. And I guess I just want to make sure I completely understand, so I want to clarify. So whenever you take the case to grand jury, it immediately gets arraigned, and that doesn't count as one of your arraignments, or it does?
When we take the case to grand jury and a true bill is returned, and the reason I'm parsing that out is because, again, your question, and I'm not disparaging you in any way, shape, or form, but when we take a case to grand jury, it is not always a guarantee that a true bill will result. They could no bill it and there's no charges, so I just wanted to clarify that. As soon as the case, the true bill is returned, it immediately, within the next day, gets sent to the clerk for filing. That places it on the hot list for arraignment.
And what is a true bill?
A true bill is a document that is returned by a grand jury, the group of citizens, and it is a determination, it's a reflection of their determination of probable cause. Probable cause that that a crime was committed and the accused committed the crime.
Okay. Okay. And then,
can I add something else?
Yes, of course.
Grand jury is different than another process, because you ask what is a true bill, and that's because I want to engage in this exchange of information. Another way for a felony charge to be brought is by information, criminal information. That does not come through a grand jury. It comes through another process called a preliminary hearing. That preliminary hearing is, again, a means of finding probable cause. Okay, so the preliminary hearing can be done one of two ways. It can be started by the filing of a criminal complaint in the magistrate court, or it can be started by filing a criminal complaint in the district court. The next step after the filing of the criminal complaint in either court is setting what's called a preliminary hearing. That's where it's an adversarial, and there's evidence and testimony, and the judge is on the bench and rules and all those things, right? Well, after that process, if it's in the magistrate court, then the bind-over order is signed, which says, okay, probable cause has been found, the magistrate court no longer has jurisdiction, the case is now bound over to district court, and then we file a criminal information, then the defendant is arraigned in district court on the criminal information. If there was a preliminary hearing held in district court, then the bind-over order doesn't exist. They just say, oh, okay, probable cause has been found, we file a criminal information, and then the court will set it for arraignment. So that's how felony charges come about in the district court. Two different ways: grand jury or grand jury indictment or criminal information. Okay. I hope that answered your question.
Yes. I kind of want to go back to this just a little bit now that I understand a little bit more of the rule, and how it's affecting the office and everything. When cases are getting dismissed because they're not being arraigned, because they're not able to, because there's more coming in than what you're able to arraign, how are you keeping track of cases that are being dismissed that need to be refiled?
I follow you. Yes. Okay. That's a very good question, and it's a very valid question. When you asked that question before, and we had our press conference, I mentioned that we sent out the letter to all of the folks, and I mentioned during that there were about 500 cases which were dismissed overnight by the court's determination, right? And we would refile, do everything that we could to refile them. That process has been ongoing, and I can tell you that we have refiled about 279 of those cases. And we do have staff members who work on that, assess that, review that, and make determinations about case viability, and bring those cases forward. So it's not a situation where the cases were dismissed and we just forgot about it. We're true to our word. We continue to press on and indict those cases which are still viable. So that's an ongoing process, and it's one that it's very interesting because honestly, there has been some discussion within the profession about whether or not the determination of the court's prior decision about those cases, if it was the right one. That query didn't come from me. The court said they get dismissed. I have to honor the court's order. There's been some inquiry about whether or not that's the right decision. I can't speak for the court. It's not a good situation. It's just not. But I can assure you that what we are doing is trying to make the best of it regardless. The case management rule would benefit from better guidance from on high.
Perfect. I think that's pretty much everything. Do you have anything else to add, even regarding transparency, that you want to tell your constituents? Do you have any comment or any response to, Amy Orlando's statements about you?
Well, you want to know why I'm pausing? Here's the thing. Like I said before, we're very busy and we just like to move on and do the work. If I get embroiled in she said this, he said that, and what do I think about Amy Orlando, or what do I think about her comments about me? Her comments were baseless. They were very unbecoming of her as a professional. And frankly, I give them no weight. So I'm not going to let my life and my ability to lead this organization get pulled down and distracted because of whatever someone else may say that has no basis and is just for the sake of creating drama. Your life your property, the lives of the people in this community, in this district, and their property, the values of our society are worthy of a lot more than drama. We deal with substantive things. And the reason I mention that is because of what has happened here recently with regard to the situation involving Felipe Hernandez and Teresa Gomez. And I've got my nose to the grindstone working that, but someone else is coming along and saying I'm a bald-faced liar because they have a concern about a report of the number of cases from a year ago, and I've already given the answer to that question. Come on. Where would you rather have me put my effort? Right? So, no, I'm not going to wrestle around in the mud and create a sideshow over something that is not substantive whenever I have a real responsibility and obligation. We just took in a case the other day associated, it's a child sex case. The child is in single digit age, okay? That child was abused, seriously abused, by relatives. It's not in the news yet. We just got the intake. That's the kind of stuff we deal with, not looking through the rearview mirror. And so if Miss Orlando or anybody else wants to trash talk me about my not answering her question or not being transparent, I got better things to do. And the people out there know it because we've been doing it. You look at the cases that go to trial, we're coming back with victories on homicides, sex cases, everything, you name it. We did this throughout COVID. We did it throughout the Great Recession, the Great Resignation. Whenever people didn't want to go to work, it was hard for us to find attorneys. Our people work hard for these folks every day. They put themselves on the line, and they do an excellent job. And so, to me, I take offense that someone would take a swipe and be disparaging of me and the people that work for me on behalf of the people in this district. And that's the way district attorneys feel. I've been a district attorney 3 times longer than Amy Orlando ever was. I was elected, she was appointed. So, she's chosen to give you her opinion. I don't know what her working relationship is with you or your news outlet. I don't want to know. My focus is on serving the people.
And then lastly, during our one-on-one right here, you said that constituents and myself would be able to access this stuff because it is public record. How would we be able to do that besides submitting a IPRA request that is denied?
Well, like I said, we have the authority to do so. And if there is a concern about that, then the remedy is in the courts, okay? But like I said at the very outset, we don't maintain the data system that keeps these records. That's maintained by the Administrative Office of the District Attorneys.
So it would be requesting that from the Administrative Offices of District Attorneys.
Some work you have to do.
Thank you.
You're welcome.
Thank you so much. And thank you for your time today.